So if you want good results, you're going to have to put an anticoagulant, put the preservative, make sure it's refrigerated as soon as possible, so that when it comes to the true analysis, you'll have good results. The truth is that even if it was not done, let's say the refrigerator wasn't working that well, or you forgot to put in the preservative and bacteria are in there, the fact is that never causes more alcohol than there was at first. It always lowers the amount of alcohol. So the results will still be admissible if, let's say, it starts off at a certain thing, and after the improper refrigeration, let's say, the blood alcohol content is 0.09, then we know that it was at least 0.08, and therefore the person was guilty of driving while impaired, let's say. But if it's, let's say, 0.07, then we'll really never know. That's the problem. So you got to do the proper refrigeration, and then we'll get the best results and the most accurate results. The thing is, after death, bacteria, they act on the body, and they can produce more alcohol in the blood. So after death, there's a certain amount of time before you can actually trust the blood samples that are taken. Of course, this depends on bacteria action, what temperature was the body, were the bacteria available, what kind of bacteria and all that. So you can't guarantee that there's going to be more alcohol in the blood after death, but it's something to be aware of. The bacterial action do not work in urine or vitreous humor or the eyeball fluid. So we've got to take blood, not only sample from blood, from dead bodies, of course. We also have to take urine samples and vitreous humor samples from the eyeball fluid. So we can compare all three, and we'll see how precise the blood was. And we can get the information from what's in the urine and in the vitreous humor. So better not to just take blood. Now the question arises, can you compel someone to take this breath test? Now the person can say, I don't want to self-incriminate. Now the Fifth Amendment, and in this country people are pretty serious about it, is that we cannot compel anyone to testify against themselves. So when they breathe into these breath tests, these alcohol breath tests, they might be testifying against themselves with their alcohol. So can they refuse it? In general, for people driving on the highways or people driving on streets, it's understood that if you want to drive on the streets, you have to consent to these breath tests. So this is not a question of self-incrimination. It's an agreement. It's an implied agreement that if you drive, you will agree to a test. However, you have every right to say that I will not drive and I will not consent to a test. However, this means your license will be suspended, usually for 6 months or a year after you refuse this blood test. It was also established in this 1966 test of Schmerber versus California. I think some guy, Schmerber, was in a bowling alley and he drank a lot. He was pulled over. He got into a car accident. I forgot what he hit, but not another person. I think he hit, a post or a guardrail. I don't even know what he hit, but whatever it is, he got into a car accident. He and his passenger were severely injured. They went to a hospital, and the police, were there. They said, we want a blood sample from this guy. We think he's drunk. He was drunk. He didn't want. We want them to, but the doctor did what the police said. Then, so Schmerber said, hey, I did not let you take this blood. I do not allow you. This is self-incrimination. You're forcing me to self-incriminate, to testify against myself with my blood. I don't want this evidence to be used against me. So ultimately, the Supreme Court concluded that it is okay for them to do. The blood is not really a verbal. It's like a testimonial self-incrimination. It's more getting evidence. And getting evidence, we can compel people to submit evidence. So this is true for blood samples, and also in the case of Schmerber versus California. Now, there are two things to note. Number one, this was done as part of their arresting him. So I don't think they can simply demand a person on the street to take their blood to see if they're drunk. I think it's probably, again, the person did something that was illegal, or they suspected, and correctly, that the person was doing something illegal, and as part of their arrest, they wanted to take the blood. So then they were permitted to do that. Also, one of the ideas was that the body gets rid of alcohol. It naturally does. The liver will turn it into something that's not alcohol, until acetic acid, acetate, whatever. So this is a case where there's evidence in his body. There's evidence that's going to be destroyed. Very often, evidence, if it's going to be destroyed, the policemen have every right to rush in there without a warrant and grab it. So that was another issue here. His body was going to destroy the alcohol, so they had to immediately get it, even from a blood test that he did not consent to. So they decided that the evidence from his blood test was admissible, and it turned out he was, sure enough, drunk. And he was, the arrest was actually correct. Same case. The problem now is not in forcing a person to testify against himself by these blood tests, but illegal search and seizure. I mean, they took his blood. I mean, again, that is again pretty serious in this case, in this country. You're not allowed to go into somebody's house, search his stuff, and take things without a warrant. So that's another thing he claimed. Hey, look, you took my blood. That's illegal search and seizure. You took my blood without my consent. But again, because the body will destroy alcohol over time, they had to do it now. Even without a warrant, they were allowed to do that. However, if it's possible to obtain a warrant, you must obtain a warrant before. If it's possible to obtain a warrant before the evidence will be destroyed, you must obtain a warrant. And if you don't, then the evidence can be discounted in a court, or considered invalid in a court and not admissible in a court. So, but in this case, of course, his body was constantly destroying the evidence, so they certainly were allowed to take the blood from him. And it was not a problem with illegal search and seizure because they had to get it before it would be destroyed. This is true for alcohol, but a case like buccal swabs, that's where they swipe the inner cheek to get DNA. Well, a person's DNA doesn't disappear over time, so you are actually not allowed to do a buccal swab unless you have a warrant first. So we know a little bit more about forensic toxicology, especially of alcohol. You should know what forensic toxicology is, how it's done. Well, what is done, about alcohol, how it gets into the body, how it's tested, how it's measured, the cautions, like the things to be aware of when testing the breath. Mouthwash, it's alcohol. Maybe that's what's causing the test to work to produce blood alcohol content that's higher than it should be. How the breath test works, the IR or the infrared light or the fuel cell, and know that it's gas chromatography confirms this. Both together will show that the person certainly was impaired. Also know about field sobriety tests, the walking back and forth, whatever it is, the horizontal gaze nystagmus, the various blood alcohol tests, and the legalities of it, and how it relates to the person's constitutional rights. And handling blood evidence, make sure it does not, make sure it's refrigerated correctly, make sure it doesn't break down due to bacteria. And even if it does, it'll be less than it should be. So be aware of that. You should know about that. For those who want to practice this and get more, and keep this more in mind, you can do these homework problems in the textbook.